Good evening. This is Brad Micklin. Just give me a second. I have to get all the audios set up, and we're going to jump right into it. Okay. Good evening. Welcome to our monthly webinar series from the Micklin Law Group. Tonight's webinar is Military Divorce, Common Mistakes and How to Avoid Them. To those that may not have been here to other webinars, let me just give you some information about how this is going to work tonight. This is a monthly webinar series that I run usually the last Thursday of every month. It's scheduled for 60 minutes. Sometimes it's longer, sometimes it's shorter. I do my best to keep it at least within that time frame. I leave some time at the end to answer questions. I will stay as long as necessary to answer any questions. So don't hesitate to ask whatever may be on your mind. I also recommend in the chat panel on your control panel that you have on the right side, there's a section to pull down for questions. And I would suggest that you write in your questions whenever they come up to you, whenever they occur, so that you know you'll get to it, even though I won't be able to address them until the end. This is a one-way communication, so you should be able to see my screen and hear my voice, but I can't see or hear you. That's why questions have to be typed, and I'll answer the questions directly verbally. I've started something new that I haven't done in a lot of my past webinars, and you'll notice there's a handout attached, which is the PowerPoint presentation I'm using. In other webinars, not so much this one, in other webinars, there are a lot of good citations to statutes and case law that some people would like to have afterwards. This is also being recorded. It will be posted to my website, www.micklinlawgroup.com, sometime shortly after the webinar. If you need it sooner than that, before you see it get posted, then just email me. We can usually get out a copy for you. Give you a little information about me if you haven't been to any of my webinars. My name is Brad Micklin. I am the managing member of the Micklin Law Group. I'm a member of both New Jersey and Pennsylvania state bars. I'm licensed to appear in both state and federal courts in the 3rd District. I started my career as a judicial law clerk for Judge Austin. He was the supervising judge of special civil litigation in Bergen County. I then went from there into Kessler and Associates in Clifton. I did complex commercial litigation for a number of years before opening my private practice in 2001. The Micklin Law Group is concentrated in divorce, family law, and estate planning and litigation issues. I handle more of the high net worth and high conflict litigations for the firm, but the firm itself is concentrated in those areas. Quick, I always list some of the recent awards I've received, not because I want to boast, but because I want to ensure that those that do not know me and haven't worked with me can feel comfortable that I have some sense of what I'm talking about. The purpose of these webinars is to give people information that they would not otherwise be able to get from a consultation with a lawyer, or even sometimes throughout an entire case, because there's just so much information out there. On the left-hand side are the more recent awards, 2014 and 15. Academy of Trial Attorneys. The middle ones, the AVO rating, actually it's been raised to a 10.0, which is a perfect score. They have their own independent algorithm for reviewing and rating attorneys. You can find them at avo.com. And then the Institute of Family Law Attorneys on the bottom. And the ones on the right are awards I received from Martin Del Hubble and the AVO search engines many years in a row. I just have one or two of them listed here. Just like I said, to give you a general sense of who I am and what you can expect when we work together, if we ever do. Let me give you a brief overview of what we're going to talk about tonight. Again, this is, as you should know, military divorces. We're going to cover the residency requirements, the Servicemembers Civil Relief Act, which is what does put most of the restrictions and distinctions between state and military divorces. We'll talk about child support, the support guidelines, and the alternatives to the support guidelines. And in those sections, I'm also going to talk very little about other states generally, so you get a comparison of how things may be on a more national basis. Then we'll go into enforcement applications, how income is utilized and determined, and then pension and military benefits. Now, what we're going to try to do is give you a sort of a comparing and a contrast. I'm going to give you a little bit about New Jersey's law, very little bit on each topic, and then we'll move into the distinctions of the military divorces and how they differ from New Jersey. Not going to go into a great depth into any one issue because there's a lot to cover. This is intended just as an overview of some of the major distinctions and some of the sort of pitfalls and traps that many do encounter. The material should be helpful to any party in a case, whether you're the litigant or a lawyer, whether you're in the military or the other spouse is. It's intended to give you just a brief overview of the important distinctions and how you should handle them. So let's jump right into it. Let's first talk about the residency requirements and how they differ between state and military. So in New Jersey, generally speaking, one of the parties must be a New Jersey resident in order to file in a state court for a divorce. And with most causes of action for divorce, you have to be a resident for at least 1 year prior to filing. There is one exception for adultery. I'm not going to go into it. It's not really germane to what we're speaking about today, but generally speaking, you must need to be here for 1 year. And that's often a very difficult requirement because of the transient nature of our society, as well as the need for many to move and separate when a relationship ends. Many times they have to move out of a state. Now they've changed residency requirements and then often are prohibited from being able to file for a divorce. That's not going to be necessarily the same when it comes to military divorces. Military divorces uniquely have several different options that people are able to choose from, where, like I was saying, in New Jersey, you're really stuck to just one. You're married to one issue, to one choice. So the three different choices that you can choose, either you have where the service member lives, the state of his residency, the spouse's state of residency, where the other person is living, and the state where the service member is stationed. And that's an important one because there's going to be a lot of issues that we talk about in here when it comes to child support, child custody issues, and state versus military laws. And which state you file in will greatly or can greatly affect certain issues. And having the choice of these of three possibly different states allows the person, whether it's the military spouse or the non-military spouse, gives you some options to choose more favorable forums for the issues that you may be discussing. So let's talk about what are the general law and rules that follow a military divorce. Most of them will fall under the Servicemembers Civil Relief Act. Now, in New Jersey, we have the rules of practice that govern matrimonial cases in state court. There is one set of rules. It is uniform throughout New Jersey, which is good. So that way, if you're in Camden County, you're going to use the same procedural rules as you would in Bergen County. And that's important, for instance, when it comes to adjournments. A lot of times you'll have a case needs to be adjourned, especially when there's a military divorce. We'll talk about some of those issues, why. In New Jersey, it's usually fairly easy to obtain adjournments on certain matters, especially when it's in the early stages. It's not automatic, but they're usually granted, at least the first one. Subsequent ones are often more challenging to receive, depending on the reason for it and the prejudice to the other party. Turning to the Servicemembers Civil Relief Act, it actually provides that military service members can get a delay whenever their rights may be affected. And that's sort of the underlying theme behind the entire act. So let's talk about just a few specifics. It's significant when custody cases are involved. Obviously, when you're talking about rights in a divorce, quite often you're talking about financial issues, and which are significant, don't get me wrong, but custody issues, parenting time, and child support issues are much more significant. You're talking about a constitutional right to a relationship. And quite often, the service member is unable to appear at the onset of a case. So the Servicemembers Civil Relief Act provides that a 90-day automatic stay be granted, which will allow the service member to meet certain other requirements to see whether or not it's going to go forward. Now, this although it's automatic, there are certain requirements that will need to be met in order to get this relief. First is you must have a writing sent directly to the court. Sending something to your spouse, sending something to the other attorney is not going to be sufficient. It must go to the judge or the family court clerk's office. Additionally, there must be something from your commanding officer stating that you are unable to leave or to get leave to attend this. And that's very important because the purpose of the Civil Relief Act is to avoid prejudice or harm to you because you're not able to appear. If you are able to appear, then there's no harm. So you must be able to show that you can appear. Now, as far as further adjournments, as I said in state court, they are possible. They can be granted also in the case of a service member's request. It's ultimately going to be left up to the family court judge and his or her discretion. The courts will look to, I think, the same issues they would when looking to a non-service member's request for an adjournment, and that would be basically good and bad faith behind the request, the rights that are being affected of the other party. But what's important to know here is the writing that is required. Don't go on the assumption that because you're in the military, you cannot proceed in your absence. And another important distinction is this is only applicable in family, divorce, and custody cases. It is not applicable in criminal cases. Now, I don't do criminal law. I haven't done criminal law since I was licensed to do so in law school decades ago. So I couldn't tell you what protections, if any, there are in criminal law. You would need to speak to a criminal attorney. But it's important to know that what I'm saying here does not apply in criminal cases. So let's turn to some of the pressing issues that you will often find in divorces, child custody. So let's talk about New Jersey's child custody. In general, New Jersey applies a best interest test almost across the board when it comes to custody issues. Now, military custody issues are going to turn on issues such as how long that person's going to be away, for whether it's extended periods of time, whether or not they're going to be moving inside or across the country. And the reason that this is significant is because it's going to have an effect on the child and the other parent's rights, whether depending on which parent has physical custody or primary physical custody. Now, New Jersey does not prevent a service member from having primary custody of a child. So even though you may be sort of mobile, you may not have a definite location, and you're moving with the child, could have a great effect on the other parent's ability to see that child, still doesn't prohibit a service member in New Jersey from having primary custody of their child, which is one of the issues I mentioned at the beginning that you do need to consider when you're choosing the forum, because I believe some other states may have prohibitions against a service member having primary custody, or maybe not even specifically, but there could be some prohibitions when there's a parent who is going to be mobile and can't give a permanent location or permanent residency for the child, may be deemed less appropriate or inappropriate for custody, primary custody. So when you're choosing which forum under those three we talked about in the beginning, this is something that you might want to research before going forward. In all cases involving the military, it's going to be important that there be a plan that's flexible for the demands of either parent. Again, the focus is going to be the best interest of the child, and they're going to need to look at both how this plan affects the child as well as the other parent, regardless of who has primary custody. Like I was saying, it's not necessarily the case in other jurisdictions. Like I say here, you should research those jurisdictions before you're moving forward to determine whether or not there's going to be an issue that you should try to resolve. Now, part and parcel to child support or child custody or child support issues. So looking at New Jersey, generally both parties and the child need to live in New Jersey for the court to have jurisdiction or power over the parties. Now, in some cases, one of the parties do move. Sometimes the child will be moving out of the state. The application in New Jersey sometimes remains where it was. Usually it will move with the child. So you should consider the other jurisdictions as well as how they factor child support. Even if you're in New Jersey and you have a service member that is the other parent, you may want to know how where they're stationed or where they may be stationed could affect your future child support issues. Now, in New Jersey, again, that's not too often a consideration. The variations between different state child support guidelines is going to be very different. Cost of living is hard to determine whether you're in Camden County or Bergen County. You're going to have significant differences. But it's across the board in New Jersey, just like the rules are. Now, when it comes to military child support, it is an important factor to consider when you're going between different states, when you have the 3 different states. It is likely to be drastically different depending on the state. As I was saying, each state will have its own set of guidelines, and you have a situation when you're dealing with a service member that not only is that service member likely in different states, but he or she may be deployed to other jurisdictions, other countries, and whether or not that person, one, has custody of their child will significantly affect child support, and even possibly their locations can affect the incomes, which we'll get to later, if they're not the primary custody. New Jersey, our child support guidelines are presumed to be accurate, so there's not a huge discrepancy or variation with that presumption. Now, obviously, the presumption is rebuttable. There are also high income cases that go outside of the guidelines, but generally speaking, the majority of cases in New Jersey are going to be by the support guidelines. You have a service member going into different states now and in the future, it's significant. You know, the New Jersey is not likely or may not likely be the one place that remains. So usually what I recommend is either file in the different states or transfer the case to the state where either you are or the service member may be. One other thing you can consider when it comes to child support and the likelihood that the relocation of the service member may affect your case, you can build into a court order or into a settlement agreement foreseeability of these issues. If you think you're going to have child support issues, you can agree in advance how to resolve them. You can also agree in advance to waive them for the best interest of your child. Parties are often free to do a great deal if they're acting for their children's best interest. Which brings us to our next topic and what kind of alternatives are there to child support guidelines. As I was saying in a moment ago, New Jersey guidelines, they are presumed to be correct without going to court on a child support application. There's very little relief that you can get. Nobody's out there to sort of help you collect a paying spouse's support absent going to court. Whereas the military, the distinction that we have in the military is they have their own set of regulations to determine child support and also the enforceability of child support. Now, generally speaking, and I don't have a great deal of experience on how other states, but my research has suggested that it's usually not going to be significantly different as you go through different states. At least my experience with other states' guidelines are not significantly different. But it's still going to be very, very important to research the differences and to learn how to set child support through your New Jersey state guidelines, but enforce them through the military guidelines, which we'll talk about in a second. The good thing about it is orders of our court will supersede the military guidelines. So if there's ever a conflict with the regulations that I cite above, you can feel confident that if you have a New Jersey court order for child support, that it's going to be first in line. And if you're going to look to get a wage garnishment, that is going to be a requirement. You will not be able to get a garnishment against a service member without a court order requiring it. I generally always recommend a wage garnishment in all child support cases. I see no reason to have it done any other way. And again, just my personal preference is that you use the family court to establish the support guidelines. I don't recommend trying to do it with the service member directly because, again, when they start to relocate or get deployed, sometimes you actually lose the ability to get in contact with them. And while you may entirely trust, you may lose contact with them, which goes back to my original statement that you want to get a wage garnishment in order to enforce these kinds of obligations. It makes it much simpler, I think, for both parties. So speaking on that term, let's talk for a moment about the enforcement issues. Now in New Jersey, enforcement's relatively a simple, well, not a simple issue, but it's a static issue, and that is that you have to go to court on a motion for enforcement of litigants' rights. There's very little that you can do. I was going to say sometimes you have an agreement even where parties will agree that they don't have to go back to court, that they can get an automatic suspension of something like parenting rights or automatic increase. But those remedies really don't work. There really is no other remedy but filing in court. Even if you have an agreement that says if he or she doesn't pay, he pays $50 a day or she pays $50 a day, you're still going to have to file a motion to get that to be enforced. Even if you have a court order or a judge tell you when you're there, you can come back and not have to file a motion. You're probably going to find out when it comes time to actually do it, you're going to have to file a motion. And in New Jersey, it's often a large burden on the parent or the parents trying to enforce it because they're already being denied their support, and it's costing them time and effort and resources to enforce what they've already fought to get in the first place. I'm generally, just on a side note for enforcement, often hesitant to tell, or not hesitant, I'm eager to tell clients in the beginning to make sure to get your rights settled, get the wage executions in place, because it is very difficult to do that in New Jersey. It can be very taxing if somebody's looking to avoid enforcement. Now in the military, as I was saying, they have their own set of rules for setting and support and enforcing guidelines. But as I said, I can't say it enough. I don't recommend it for the establishment of the child support order. I generally believe that New Jersey is going to be more generous to you, but it is helpful for enforcement. You don't want to let enforcement slide by because of the military policy under the Civil Relief Act and the statutes I cited is to ensure that service members keep current and support their children. Now, the one issue that may be good or bad when it comes to support issues is that the military considers the failure to pay a child support obligation a potential reason for a dishonorable discharge. Now, the good for that is obviously it's very strong incentive to encourage the service member to be compliant. The bad is that if there is let's say a benign reason or some other reason other than intent that they were not able to pay a dishonorable discharge, may cause the loss of the income that's paying the support in the first place. There are a lot of people who have made a career out of serving the military, and if through some action, no fault of their own, fall behind on child support and get dishonorably discharged, that sort of source of support for both the child and the service member are going to be lost. So it kind of cuts both ways, but it is very common to use this as a way to sort of coerce compliance with support obligations. So next we're going to talk about how income is determined for child support. This is one of the probably two greatest areas that military law and procedure is very different from state procedure. And those that aren't familiar with military divorces really need to be focused on this issue and the retirement issues that we'll get to in a few minutes. These are where you're going to possibly do the most harm to either your client or yourself if you don't know the difference of the upcoming next few issues. So first, in New Jersey, and probably most states, there are simple evidentiary ways to establish income. Normally it's your W-2, your 1040, tax returns, pay stubs, anything that evidences a person's income. If we're not able to get that kind of information, if you're self-employed or if there's a question of how much money is missing, sometimes we use accountants like for business interests. You may use other experts if there's a question of underemployment or hiding income. But again, topics beyond the scope of what we're doing here today. Generally, you're going to look at your standard tax documents for standard income issues. Now, with military, it's determined by something called the Leave and Earning Statement, an LES. This is sort of the equivalent of the military's W-2 form. So you're going to need to understand this and get a detailed review. I do not ever recommend doing anything support related without seeing this statement. I don't even recommend taking the service member's representation of their income, not because of a trust issue, but because they may not fully understand all the things that are going to be considered as pay. It's not just dollars in their hand. Military service members may receive something called a basic housing allowance, which is, as it sounds, what it's for, and that will show up in a separate column in your LES. There are basic allowances for subsistence. Excuse me, I'm drinking some coffee. That will also show up in a separate separate portion of your LES statement. There are often cost of living allowances. And then there's also several other allowances that could be potentially added. Every service, well, not every, but most service members may vary. But some examples, there are sometimes clothing allowances, hostile fire pay, hazardous duty pay, and other items that aren't going to be considered as we normally consider income. So it's very, very important to get the statement and review it, again, not because of a trust issue, but because many service members don't understand the type of benefits and additional allowances. And I think it's going to change as their service history lengthens, as the type of deployment that they're sent on and the responsibilities will change. I think their additional compensation issues will also change. So, the point to take from that is always get the LES and scrutinize it. If you don't understand something, find out. And also find out to what extent it's going to change in the service person's future. Now, next issue that is one of the most significant is understanding the differences of how pension and retirement accounts are handled. There are a number of differences. First, let me just talk. In New Jersey, generally pensions are going to be divided by something called a Qualified Domestic Relations Order, otherwise called a quadro. A Qualified Domestic Relations Order is a court order that allows a pension plan to be divided from one account for the employee spouse to two accounts, and one being for the employee spouse and one for the divorcing spouse to receive. The laws that create pensions and pension protections do not allow the employer to separate a pension for somebody other than its employee. The purpose of having a quadro under state law is to give that employer the authority to divide the account for a divorcing spouse to get his or her share. So it's the only way that you're going to get a pension paid out in New Jersey, and I think most of the states in the U.S., is going to be through the pension. Military pensions are subject to equitable distribution. They are divided like assets and pensions are divided in New Jersey, but they don't use a quadro. A very important distinction. They're divided by the Defense Finance and Accounting Services, and they can and will make a distribution if a 10-10 rule is met, which obviously begs the question of what is a 10-10 rule. So in order to satisfy a 10-10 rule to get pensions divided in a divorce, the marriage first has to have lasted for at least 10 years, and it must have coincided with 10 years of the service member's service. If it doesn't mean that you get zero. The courts still have the authority to divide a pension separate from this 10-10 rule, but it's going to be significantly different. One of the main differences is going to be if it's not met, the difference has to be paid to the spouse. So the important point here is that if the 10-10 rule isn't met, the spouses still can be entitled to the pension and still get it. But here the service member is going to have to pay it directly to the spouse. And you're going to want to consider this carefully, because if you're doing this by an agreement or by a court order, you may need to put in certain languages that specify how it's going to be paid and your rights to enforcement if it isn't paid. Because again, the DFAS won't be helping you. So you need to make sure that it's set up and garnished, because again, the 1010 rule sets amount by how much you can garnish. So let's say you do have the 1010 rule met, but maybe the courts are going to give an unequal distribution of the pension, because what we didn't talk about in New Jersey is pensions are divided by what's called equitable distribution. Doesn't mean equal distribution, it means based on what's fair. There may be many reasons why the court determines that the non-service member spouse should receive more than 50% of the service member's pension. So let's take a look at what you are able to attach through the DFAS. Okay, there is a 50% limit on equitable distribution and a 15% limit on both equitable distribution and child support, which means the total can't exceed 65%. So if you're getting a court order for child support and you're getting a court order for distribution of a pension that is greater than this 65% of the compensation under the LES, you're going to have an agreement or an order that specifies the direct payment of that additional sum of money, which brings us back to your enforcement issue. So it's going to be important. Now let's look at a situation where you have a longer marriage and a greater share of benefits. 2020 military benefits. First, in New Jersey, when you're divorced and you've divided your assets and your debts, that's it. There are no additional benefits to be received or accrued whatsoever. Medical and dental benefits end. A lot of people aren't aware of that. You can't usually be on a family plan, even by agreement in New Jersey, once you're divorced, because you're not a family anymore. Most insurance companies will reject that, so that terminates. Future retirement benefits do not vest in anybody but the earning, the employee spouse. And estate plans, if you had one that provided for the other person to receive something, automatically terminated by filing a divorce. So basically, you get divorced in New Jersey, whatever you get is what you get, and whatever you and the other person acquired after you're married is yours to keep. The 2020 rule of military benefits provides something significantly different. The non-service member spouse is entitled to all military benefits that were available during the marriage if the 2020 rule is met. Obviously, let's talk about what that is. Marriage must be at least 20 years. The service member must have served at least 20 years. And there's a 20-year overlap of service and marriage. Now, at first glance, that may seem that it's obvious, but it really isn't. You could have somebody enter the service at 20 and get married at 35. So there's only going to be, and then stay married for 20 years. It's not going to trigger the 2020 rule. There's going to be a lot of instances where one of these 20s does not overlap properly. There is an exception if there is an overlap less than 20, but 15, and that's the ability to receive medical coverage for one additional year. May not seem like a lot compared to what you can receive under the 2020 rule, which we'll get to in a second. And if you remarry real quick, you will lose the benefits. I think I'm missing a slide here of some of the rights that do continue. Let me just go back. I believe the, well, like we said, medical coverage can continue. There are tax-free shopping available on some bases. The divorcing spouse in the 2020 will continue to have access to that. Some bases have recreational opportunities, and the divorcing spouse will also be able to continue to use those. So it's very significant to know what are the benefits. If you have the 2020 rule in effect, you want to research what ancillary benefits other than a pension and income that they receive because you will be entitled to that. And you need to have this brought to the attention of the judge. And the thing to remember in closing here is most divorcing attorneys and most family court judges, in my opinion, don't have to deal with a great many military divorces. So, and I'd rather guess that maybe certain counties have more than others. Maybe certain counties that are like closer to bases or closer to airports may have greater enlistment numbers. But so don't trust, no, don't trust. Don't depend on the family court judge to know these issues. Don't depend on your lawyer to know these, and don't depend on the other person and his or her lawyer to know these issues. They may innocently be unaware of the distinctions, but if you don't know them and you walk into a divorce ignorant of them, you may be forever barred from getting the things that you and your family are entitled to. That is the end of the presentation to that extent. As I indicated when we started, it was going to be a very brief overview so you'd be aware of the major issues that are necessary. I'm going to take 1 second just to get my paperwork arranged, and I'm going to take any questions you may have. Just give me 1 second. All right, I'm not seeing any questions. Let me just take a second, then I'm going to do a quick poll. Now, the information when you answer this, it's not going to be displayed. And I forgot to say when I started the presentation that your attendance is confidential. I do not believe anybody else who attends can see anybody else who attends. I get to see everybody who attends. All right, going to launch next question real quick. This is just so I can get a sense if this is good time for those that attend, if I should consider rescheduling them. Next is to find out the general sense of my audience, to make sure that I'm serving the right people. And lastly, in case any of those have additional questions that maybe I didn't get to, you want to schedule a time to meet, just give me this answer there so I'll know. I'll get the responses sent to me. And as I mentioned when I opened the webinar, and I'm going to close it soon, this will be posted on my website, www.micklinlawgroup.com. Usually it takes a week or so to get up. If for some reason you need it before then, you can email me and I can probably get a copy to you. And if you have any questions that you didn't get to ask, you can email them to me also. I'll do my best to address it. That being said, unless I see any questions pop up, it looks like it's going to be the end of our webinar. Hopefully it was helpful to you, and hopefully we'll see you next month. Like I said, we do this the last Thursday. I'm sorry, I don't know the date or topic for next month offhand. I forgot to look up what my schedule is, but it will be posted on our website also. Upcoming webinars are already listed, so you can see the next few we have and register as soon as you get a chance. With that, I hope, again, this was helpful, and I hope to see or hear from you at next month's webinar. Have a good night.